Hey everyone, welcome back to the channel. It's great to be here as always. Thank you for tuning in. Holy haircut. That was me yesterday. This is me today. You guys have been telling me I need to get cut for a while, but speaking of the dapper, I have a message from the man, the myth, the legend himself, Lawrence DeMonico.
All right, now first, I want to give a great big shout out to the folks at the National Association for Gun Rights, Texas Gun Rights, and the amazing people at the Dillon Law Group. Now, for the big news. We frickin' won, guys. Judge Reed O'Connor of the Northern District of Texas just granted our motion for summary judgment and denied the government's motion. 100% complete, period, done.
Before we get into the nitty gritty here, I wanted you guys to see the man's face. That is the face of a man that has stared down the near infinite power of the federal government, challenged them in open court, and frickin' won. That said, we got a lot of reading to do today, so I'm going to go ahead and take my capitalism break right now, and then we'll hop into what the court actually said. Today's video is brought to you by XS Sights, and I've been using XS for almost a decade now, and I will admit that when I first started being introduced to XS Sights, I didn't get it. It wasn't until I took a Force on Force class that was a low light class that I was like, oh, there's no other sight in the world. This is what we have to use. And I've been using them ever since. I gravitate towards their big dot sights for my pistols, but the same technology is available in the regular dot size. XS continuously pushes the envelope, such to the point that they even recently came out with fiber optic sights for those people who are completely wrong about how to use sights. Special thanks to XS for making today's video possible. Now, I obviously can't read this entire document to you. It is 64 pages, and there's a lot of really great stuff in here. So I do suggest that you go read it. I've ridden through the entire thing, and he goes through several thought processes. That is the Judge Reed O'Connor. And one of those big ones is Chevron. Even though they didn't expressly ask for Chevron, the judge kind of smacked them down for trying to worm their way in there, you know, as they do with that kind of thinking. But the big one was Cargill, which is the bump stock case that was decided just a little bit ago, like last month. I think we covered that one. Yeah, I'm pretty sure it was a month ago. But anyway, how big of a role that played in the ultimate conclusion, guidance from the Supreme Court above. We kind of knew that this was going to go that direction. And Judge Reed O'Connor does a really good job of deciphering what the threshold for machine gun is as it relates to the Supreme Court decision in Cargill, and basically says that the FRT and FRT-like triggers do not surpass that threshold. So what I'm going to do now is take you down to the conclusion that starts on page 60, and I think this is where we're going to get the meat, if you will, that we're all wanting. There is no denying the tragic nature of the Las Vegas shooting that motivated the final rule. But no matter how terrible the circumstances, there is never a situation that justifies a court-altering statutory text that was democratically enacted by those who are politically accountable. That responsibility belongs exclusively to Congress. The Constitution assigns such legislative choices to the appropriate elected officials, not life-tenured judges and unelected bureaucrats. Rather than respect this intentional feature of our democratic system, defendants chose to advance a policy agenda wholly divorced from the NFA's statutory text. Thus, to allow defendants' unlawful action to stand would be to functionally rewrite the National Firearms Act. That is not how our democratic system functions. As Chief Justice John Marshall put it, it is emphatically the province and duty of the Judicial Department to say what the law is, nothing more. This remains true even when shocking events may underscore the need for legislative change. And even when this prudent constraint produces undesirable results, one must remember that circumventing the democratic process to effectuate desired change undermines the animating policy goals upon which our system rests. A democratic path to change already exists. By jumping the gun, defendants rob Congress of the ability to capitalize on political support to alter the statutory language following the Las Vegas shooting. Indeed, multiple bills on this exact issue were pending in Congress when the defendants decided to act. None of these bills were given the chance to become law. As is often the case, public attention waned, taking with it the momentum for legislative action. But this result is even more pernicious than the mere inability to enact legislative change. Each time an agency circumvents the legislative process, it chips away at the most prudent reason for separation of powers. That is, ensuring unelected and unaccountable individuals do not make the law. This reason alone compels the court's decision today. For the foregoing reasons and the above admonitions in mind, the court grants plaintiffs' motion for summary judgment and denies defendants' cross motion for summary judgment. Specifically, the court orders the following. 1. The court vacates defendants' unlawful classification of FRTs as machine guns. 2. The court declares unlawful defendants' determination that FRTs are machine guns. 3. The court enjoins defendants, along with their respective officers, agents, servants, and other cucks, from implementing or enforcing against the parties in this lawsuit in any civil or criminal manner described below. The ATF's expanded definition of machine guns to FRTs that this court has determined is unlawful. A. Initiating or pursuing criminal prosecutions for possession of FRTs. B. Initiating or pursuing civil proceedings. C. Initiating or pursuing criminal prosecutions for representing to the public of potential buyers and sellers that FRTs are not machine guns. D. Initiating and pursuing civil actions for the same thing. Echo, sending notice letters or other similar communications stating that FRTs are machine guns. Foxtrot, seizing or requesting voluntary surrender of FRTs to the government based on the claim that FRTs are machine guns. Golf, destroying any previously surrendered or seized FRTs. And hotel, otherwise interfering with the process, sale, manufacture, transfer, or exchange of FRTs based on the claim that FRTs are machine guns. 4. The scope of this injunction covers the individual plaintiffs and their families, the organizational plaintiffs and their members, and the downstream customers of any commercial member of the organizational plaintiff to the extent that it does not interfere with other courts such as the EDNY lawsuit civil jurisdiction over the Rarebreed products. The court further enjoins defendants from pursuing criminal proceedings and criminal enforcement actions against Rarebreed parties on the grounds that FRTs are machine guns. 6. The court orders defendants to return all parties, including manufacturers, distributors, resellers, individuals, all FRTs and FRT components confiscated, seized, pursuant to their unlawful classification within 30 days of this decision. 7. The court orders defendants to mail remedial notices correcting their prior mailing campaign that warned suspect FRT owners that possession of FRTs and FRT components was purportedly illegal. Every year, our country commemorates the revolution waged against a tyrannical executive. To safeguard against future tyranny, our founders' documents designed a system that prevents undue concentrations of power in order to protect important rights and to ensure that legislative consensus is reached before enacting laws on the most important issues in society. Such foresight is especially prudent in cases like this one. Indeed, while this case may seem focused on firearms, it represents so much more. It is emblematic of a devastating problem that increasingly rears its head in federal courts: rampant evasion of the democratic process. Few issues more accurately underscore this problem than the present case. Our nation would do well to remember the very reasons and spirit that inspired our democratic system of governments in the first place. So ordered, Judge Reed O'Connor, United States District Judge. God damn. Love me some Reed O'Connor. I think that Judge Reed O'Connor has done a good job writing this in such a way that the general public can understand this. Quick note, I am not an attorney. This is not legal advice, but what this says is that if you have one of these things, you are covered. Now, does that mean that I would go out there and start flaunting the fact that I have them? Well, that's your own discretionary thing because, again, this is the district court. This has the appellate court, the en banc, and then potentially the Supreme Court. Will the ATF appeal this? I'm sure that they will. At least, well, I don't know. This will be the Fifth Circuit, so they very well may not appeal this decision. we will see what happens. We will track this over time, but I fully expect this to go to the next level at least. But I do see the logic of this decision here going to the Fifth Circuit and them being like, yep, Judge Reed O'Connor did a good job over there. Let's go ahead and knock that down. The only thing that I potentially see being a problem is the downstream customers thing, because they always try to attack standing. Do the downstream commercial users of these devices end up covered? Do they have standing? And Reed O'Connor says they do, because you guys just changed the rule whenever you want, and that has consequences for the downstream consumer. So given that the Chevron doctrine has been struck down, and the criminal aspects of them changing their mind would carry large downstream ramifications, I could see the court at the Fifth Circuit or the en banc level saying, yeah, Reed O'Connor did a good job. That will remain to be seen. I want to know what you guys think about this in the comment section down below. Do you love you some Reed O'Connor as well? I know that I do. And hopefully we'll see another video here at the VSO Gun Channel.